Good morning, everyone. My name is Patricia Wunder, and I am the moderator of the webinar series. We want to welcome everyone today for a very special presentation on the immigrant eligibility for public benefits. I would like to tell everyone that at the end of today's presentation, we will have a question and answer period. So if you have questions during the presentation, feel free to send a message through the chat to me, and the presenters and I will answer your questions at the end of the presentation. So my name is Patricia Wunder again. I am an instructor at CUNY School of Professional Studies. I've been an instructor for about 6 years now, and I'm also a partner at my own law practice, which is Johnson Wunder PLLC. We're very lucky today to have two presenters who are very well expertise in the field. We have Barbara Weiner, who's a senior attorney at the Empire Justice Center, and we have Susan Welber, who is a staff attorney at the Legal Aid Society's Law Reform Unit. So I want to thank them both for lending their expertise and sharing the time with us today. We have two presenters of this webinar series, CUNY Citizenship Now and CUNY School of Professional Studies. And the websites are listed there if you're interested in either of the sponsors. I want to talk to you a little bit about SPS, which is the School of Professional Studies of CUNY. As I said, I'm an instructor. I've been an instructor since 2005, teaching in the classroom, and we also have online classes, which is a really great solution for many people. And it's really a unique program. And there are classes such as Intro to Immigration Law, which really is the foundation of immigration law principles, and business immigration law, family-based immigration law, proceedings in immigration court, which talks about a lot of deportation matters and criminal matters, and naturalization and citizenship. If you are interested in this unique program to learn more about immigration law and obtain a certificate in immigration law, feel free to contact the website, and it's listed on the top of the screen for you again, which is sps.cuny.edu, and the website will give you a lot more information about the program and the courses. You can contact CUNY. You're more than welcome to contact me also. We would love to have you join us in some of our course offerings. The other sponsor of this webinar series, and very, very lucky to be having these series sponsored, these free webinars, is CUNY Citizenship Now. Now, it's a really exciting time for CUNY Citizenship Now, because in April, CUNY Citizenship Now, in conjunction with the Daily News, which is a paper in New York City, they are having a call-in event. And this call-in event has been going on for many years. And it has helped over the years over 85,000 callers, providing free immigration information. The call-in event has volunteers come for 5 days, all day, and people are able to call in, and the volunteers provide confidential free immigration information. So if you are interested in Citizenship Now, which not only does the call-in, but also does citizenship events all over the city, all during the year, in addition to the call-in and the citizenship events, there are also immigration centers all over New York City where you can actually go in and get free immigration advice. So the website is down on the bottom. If you want to register, you can go to cuny.edu/citizenshipnow/volunteer, and you can actually register to be a volunteer. Now, you don't have to worry if you don't have immigration experience, because the great thing about Citizenship Now is that they will train you. And actually, there will be training on various immigration issues streamed on the web on March 30th. So mark your calendar. For March 30th from 9 to 5, you can actually on the web view the trainings that Citizenship Now will be having all day on various immigration issues. Feel free to view the cuny.edu Citizenship Now website for more information about the call-in, about registering to be a volunteer, and about the training. So we're going to start our substantive portion on immigrant eligibility for public benefits, and I'm going to turn it over to the presenters.
Hello, this is Barbara Weiner. I want to welcome everyone to this presentation. I also want to mention that the rules and that we are about to talk about are complicated, and we're hoping that you will be able to use the PowerPoint that we're going to go through later on as a kind of reference guide. So don't worry about if you don't get all the rules all at once as we go through this. But before we go into the heart of the presentation, I want to give you a quick summary of what we'll be covering. First, we want to give you a short description of the several benefit programs that are critical to meet the needs of low-income people. Then we're going to get into the way in which a person's immigration status is evaluated when that individual is applying for these benefits. And finally, we'll be providing you with the rules themselves on the immigrant eligibility in these major benefit programs on which poor people must rely. And I'll just give you a little bit by way of introduction to this whole area. The roots of the rules that we'll be covering lie in a 1996 piece of legislation that was passed by Congress and signed by then President Clinton on August 22, 1996. It was called the Personal Responsibility and Work Opportunity Reconciliation Act, and its stated purpose was to end welfare as we know it. The view of that conservative Congress being that people had come to rely on welfare more than they should. Underlying all of the rhetoric, of course, was the desire to save money. And this was basically done through the welfare reform legislation in two ways. Congress ended the federal welfare program as an entitlement. And what that means is for the first time since the Depression, when the federal welfare programs were established, a person could meet all of the eligibility requirements of the program and still be told, sorry, there's no money left. On top of that, a family could no longer get federal welfare benefits for more than 5 years in their entire lifetime. Secondly, and this is of course the focus of our presentation, Congress severely restricted the access of immigrants to the federal welfare programs. And a first in U.S. history, and going against all court precedent, Congress told the states that they too could restrict the access of immigrants to state programs, as long as they didn't make their rules narrower than the federal ones. A few states like New York, with a substantial immigrant population and a constitutional requirement to provide care for the needy, ended up having to fill the many holes left by the 1996 Congress in the federal safety net. It did that by providing state-funded welfare benefits when people reached their 5-year limit, and by expanding the access of immigrants to state-funded safety net programs. And that's why we're going to be dealing to some degree with the rules in New York, which have expand the access of immigrants in other kinds of statuses to the state welfare and medical assistance program. I'm now going to turn it over to Susan.
Okay, so when we say public benefits, when we're talking about public benefits, what exactly are we referring to? Well, I'm going to briefly describe the public benefits programs that we're going to be describing the eligibility rules for when it comes to immigration status. And I just want to highlight the 3 reasons I think it's important to be familiar with the public benefits programs themselves and not just the immigrant eligibility rules. 1, there's no point in knowing who is eligible for what benefits when you don't really know what benefits are available. So it helps you whether you're a counselor or whether you're considering benefits for yourself. It helps you to know what the options are. Also, the source of funding for the benefits, whether it's federal, state, or local, is important to understanding who is eligible for what. Finally, if you know someone who's interested in applying for benefits, or you yourself are interested in applying for benefits, it's helpful to know what the different benefits programs are. The slide you're looking at now indicates the major federally funded benefits, and the subsequent slides explain a little more detail, and you can look back at those for reference later. But I'm going to tell you what I think the basics are that you need to know. First, SSI stands for Supplemental Security Income, and this is a benefit that only people with low income are eligible for, and because it's only available for people with low income, it's known as a means-tested benefit. And there are essentially two categories of people who are eligible for SSI. Persons who are elderly, which by the Social Security Administration standards is over age 65, or people who are disabled, both adults and children. And when we're talking about adults who are disabled, we're talking about adults who are, because of their impairments, are unable to work, essentially, or not able to participate in the national economy. And of course, the SSI is administered by the Social Security Administration, a federal agency. The next benefit that many of you are probably familiar with is something that we know as food stamps, but which actually has a new name, which is Supplemental Nutrition Assistance Program, or SNAP. And this is a program that's administered by the federal agency of the U.S. Department of Agriculture, and it consists of a monthly grant that can only be used for the purchase of food. And like SSI, it's a means-tested benefit, meaning that it's only available to persons with low income. Other benefits that are available that are federally funded include energy assistance and childcare subsidy programs, which you can see on the slide in front of you now. Another benefit that is also available that's federally funded is housing assistance. And we're not really going over the housing assistance rules today, but there are separate rules governing which immigrants are eligible for housing assistance. Now, in addition to federally funded benefits, some benefits are funded by a mix of federal, state, and local sources. Even where a benefit is funded in part by the state or local government, if there's federal funding involved, then the program must be administered in accordance with federal law. And this includes immigrant eligibility rules. So even though the benefits we're going to talk about, TANF and Medicaid, are not completely federally funded, essentially the same rules that apply to SSI and food stamps apply to these benefits. The first mixed funding benefit we want to talk about is Temporary Assistance to Needy Families, or TANF. And this is a funding stream that was created by the Personal Responsibility Act passed in 1996 that Barbara referred to earlier. This money, TANF money, is used for, among other things, what we commonly know as the public benefit called welfare or cash assistance. This is the basic form of public benefit that I think many of us are familiar with. It's a cash grant that people can use for their basic needs, for their basic expenses. In New York, the TANF-funded cash grant is called family assistance. Whichever state you're in, no one can receive TANF or federal welfare for more than 60 months or 5 years in their lifetime, as Barbara mentioned. The other mixed funding benefit that we wanted to highlight is Medicaid, and I think most people are familiar with Medicaid as health insurance for low-income people. So we've covered federally funded benefits, mixed federal state-funded benefits, and now we want to look at two state-funded benefits, purely state-funded benefits. As Barbara mentioned, we use New York as an example here because both Barbara and I practice in New York, but many states have their own state-funded benefits. In New York, state-funded welfare, which is known as safety net assistance, is available, as well as a form of Medicaid that's purely funded by the state. So if there's already a mixed federally funded form of welfare, the TANF benefit that I mentioned, why do we need even need a wholly state-funded version. Same with Medicaid. If there's federally funded Medicaid, why do we need state-funded Medicaid? Well, there are two basic reasons. One is that even before welfare reform went into effect in 1996, there were some categories of people who were not eligible for the federally funded benefits, typically single men and women without children. Therefore, if a state is concerned about providing a social safety net to all its residents, the state needs to fund and provide benefits to those groups that are excluded from federal eligibility. After welfare reform, when many immigrants, including immigrants with children, were excluded from federal benefits eligibility, the state forms of assistance became even more important. And as Barbara mentioned, in New York State, there's also a constitutional imperative to provide benefits, a social safety net for all residents, not just those who are eligible for federally funded benefits. The first state-funded benefit we want to mention is safety net assistance. This is a welfare grant for which families and individuals who are not eligible for TANF-funded family assistance are eligible. And the second is state-funded Medicaid. State-funded Medicaid operates just like federally funded Medicaid, but is available to a larger group of state residents. That's our overview of the benefits that are available that we're going to be discussing the eligibility rules for.
So now we're going to go to the immigrant eligibility rules themselves for these federal, state, and locally funded programs. The basic rule, and this is the rule that comes out of the 1996 Welfare Reform Act, is that to be eligible for any benefit, any federal public benefit, not even just the programs we've been talking about, which are specifically designed for poor people, an immigrant must have what's called a qualified alien status. I want to emphasize here that qualified alien is not an immigration status. It is a benefits-related category, and it's actually a list of various immigration statuses. And these are, if an immigrant is not on the list, if an immigrant has a status that is not on the list, they will not be eligible for federal public benefit. So who's on the list? The first category are what I like to call the humanitarian-based immigrants. And these are immigrants who generally are permitted to come to the U.S. and to live here because they face persecution in their home country. So, for example, refugees and asylees. An asylee, the difference between those two is that a refugee comes into the U.S. as a refugee. An asylee is someone who comes to the U.S. in some other status, or perhaps no status at all, and applies for asylum once they've gotten into the country. Then there are people granted withholding of deportation. Those are people who are put into deportation or removal proceedings, but who make the case that if they were going to be sent back to their home country, they would be persecuted for their political beliefs or their race or nationality or their religion or one of those protected grounds. Amerasians are a specific category that was established during the Vietnam conflict. Then, and Cuban Haitian entrants, the special status we have provided for Cubans who come into the country, and for a certain historical period for Haitians. And then in 2000, Congress added victims of sex and labor trafficking to the list of people who would be treated as a humanitarian-based immigrant. And I've separated them out in part because this group has enhanced access to benefits. They have fewer barriers to the means-tested benefits that we've been talking about. Lawful permanent residents are also considered qualified aliens, and a lawful permanent resident, that's a person with a green card, and there's a picture of a green card on your slide here. Lawful permanent residents are permitted to live in the U.S., to work in the U.S., to travel, and they are allowed to petition for the immigration of certain family members like spouses and children. Another status that's called, that's in this group called qualified aliens are people who've been granted parole for a period of at least 1 year. Parole is actually a rather rare grant, and it's discretionary, and it's provided to people who are in a special humanitarian kind of crisis. An example would be that after the earthquake in Haiti, many children were paroled, Haitian children were paroled into the U.S. The final category of qualified alien status are battered spouses and children of U.S. citizens or lawful permanent residents. And these are people, the battered spouses and children have, under the Violence Against Women Act, a means of petitioning for status on their own behalf rather than relying on the abuser, the U.S. citizen or lawful permanent resident abuser. And somebody who is qualified under the Violence Against Women Act can access benefits, means-tested benefits, even before they actually get their lawful permanent resident card. Now, one of the most difficult areas in this whole area is the verification of status. The requirement from the Welfare Reform Act of 1996 is that immigrants must provide verification of status or evidence of status in order to qualify for benefits. For lawful permanent residents, the most common immigrant documentation that confirms the person has this status is the green card, which we saw on the previous slide. Sometimes, when the green card has not yet been issued, immigration will put a stamp in the person's passport, which connotes lawful, temporary evidence of lawful permanent residence. The humanitarian immigrants that we mentioned, refugees will have refugee documents. People granted asylum will have the court order that grants them asylum. In addition to those kinds of documents, employment authorization cards and green cards they all carry codes, and the code can be read to describe the basis for this status. So if a person doesn't have their refugee document handy, they may have an employment authorization card which has a code on it which lets the social services departments know what their status is. Other very common documents are visas. Visas are what a person gets when they're abroad and they come into the country, and it tells the basis on which the visa was granted. And in addition, when you arrive at a port in New York or anywhere in the country, you go through customs, and if you have permission to come into the country, you would be issued what's called an I-94 arrival departure record that will also verify or confirm what your status is. And finally, what's called a USCIS I-797 notice of action. That is the way in which immigration communicates with immigrants who are applying for benefits, is through these notices of action. And so the notice of action will reveal what type of immigration status the individual will have. Now, we talked about the fact that for federal public benefits, you must have a qualified alien status. Congress in 1996 made it even harder for immigrants to access what are called means-tested federal benefits. And we talked a little bit before, the benefits that Susan went through initially when she was talking about the federal benefits are the means-tested benefits. And so what did Congress do that makes it more difficult for these, for immigrants, even those who are in a qualified alien status, to access these benefits? Well, first, a 5-year bar was erected for most immigrants, other than the humanitarian-based immigrants who come into the country after August 22nd, 1996, which means that most immigrants, regardless of what's happening with them, whether they lost their job, their house burned down, they were in a terrible car accident. For 5 years, no federal benefits are available for the vast majority of immigrants who first arrive. And we're only here talking about legal immigrants. Immigrants who are in this country without status have very little access to benefits at all. Then there are the immigrants who are sponsored by family, so a U.S. citizen who asks that his or her spouse be allowed to come into the country, or a child. For immigrants who are sponsored by a family, when they apply for benefits, the sponsor's income, regardless of whether or not it's actually being supplied to the immigrant, is deemed, which means it's counted when the welfare department determines whether the person is financially eligible. So if I'm the sponsored immigrant and I have no income and I go to the welfare department and they may ask, what is your sponsor's income? And they will deem that income available to me unless I would be indigent or without food, then that's an exception to the deeming rules. I should say in New York State there is no deeming for state benefits. Another concern for immigrants who are sponsored is, of course, that their sponsor will be liable to repay the benefits if the immigrant is required to access those means-tested benefits. And that liability, since 1997, lasts until either the immigrant becomes a citizen or has a substantial work history, so that they can be credited with a 10-year work history in the Social Security system. Of course, by that time, they may not need means-tested benefits anymore. So just to review quickly, the federal means-tested benefits that we've been talking about that have these extra conditions attached to them are the Supplemental Security Income Program for elderly and disabled people, the Food Stamp Program, the Temporary Assistance to Needy Families Program, and the Medicaid program, both for adults and for children. Okay, we're going to now open up our poll, and the question we are asking, and we'd like you to make a choice when we show you what the choices are, is which of the following is a qualified alien status? And your choices are A, a legal permanent resident, B, PRUCOL, C, battered spouses and children of lawful permanent residents and U.S. citizens. And your final option is to pick D, which says A and C, but not B. So legal permanent residents and battered spouses and children, but not PRUCOL. So we'd like you to think about that and answer that question, and we'll then turn to see how people have responded. Again, the question is, which of the following is a qualified alien status? That is a status making you eligible for federal benefits. We have lawful permanent residents, PRUCOL, battered spouses and children, or finally D, A, and C, but not B. Okay, so we're looking now at the responses to the questions, and the overwhelming number of you got it absolutely right. It is A and C, but not B. And no one picked the status PRUCOL, which is not a qualified alien status. So everybody was right on that. The few of you who just picked legal permanent resident or the battered spouses and children are, of course, right in that those are qualified alien statuses. But since both are both legal permanent residents and battered spouses and children are qualified alien statuses, the right answer is D. So congratulations.
Okay, so now let's see how the rules that Barbara just went through get applied to each of the benefit programs we went over in the beginning. This is the reason we assume you signed up for this webinar. This is the payoff. You want to know who is eligible for what. So that's the question we're going to try to answer. Before I get to that, I just want to be a little more specific about what I mean when I referred earlier to low-income people being eligible for some of these programs. Basically, eligibility for almost all the means-tested programs is keyed to the federal poverty level. And the federal poverty level, you can just Google federal poverty level and you'll find the level for 2011. It changes every year. And just to give you an idea of what that level is, for a household of one on a monthly basis, if you're going to meet the poverty level, you have to make less than $908 a month. If you make more than $908 a month, basically the poverty level would say that you're not living in poverty. So if you make $1,000 a month, according to the poverty level, you're not living in poverty. If you're a household of two, you need to make less than $1,226 a month. For a household of three, it's $1,504 a month. So you can see these levels are very low, particularly when you're thinking of a household of three, of a parent and two children, or two parents and one child. $1,500 a month is very little to live on. And so in recognition of that, the benefits are keyed to the poverty level. So for example, for food stamps, if you want to get food stamps, you just have to make less than 130% of the poverty level. So it's not, you can make a little bit more than $908 a month. For if you're disabled, you can have up to 200% of the poverty level and still be eligible for food stamps. In New York State, for cash assistance, which is basic welfare, you can make up to 185% of the poverty level. So even though those levels are very low, you can make almost double those levels and still be eligible for certain means-tested benefits. So hopefully that gives you an idea of what we mean when we say low income. So the first federal benefit that we want to talk about the eligibility rules for is Supplemental Security Income, SSI. So who's eligible for what depends on, in some part, whether the person we're looking at was here lawfully before August 22nd, 1996, or came after August 22nd, 1996. And remember, August 22nd, 1996 is the important date because that's the date that the welfare reform law was signed into law back in 1996. So for SSI, if you were lawfully residing in the United States before August 22nd, 1996, then to be eligible for benefits, you had to have been receiving SSI before that date. So if you were receiving SSI pre-8/22/96, then you continue to be eligible after 8/22/96. Likewise, if you were here before 8/22/96 lawfully and now you've become disabled, you can prove that you can't work, then you're also eligible for SSI. If you entered the United States post August 22nd, 1996, you're only eligible for SSI if you're one of the humanitarian-based immigrants that Barbara went through. That's refugees, asylees, Amerasians. But you're only eligible for a certain amount of time after you entered. And this is essentially Congress's way of promoting humanitarian-based immigrants to become green card holders or legal permanent residents or citizens if they need to for the purposes of benefits eligibility. Likewise, if you came after 8/22/96 and you're a green card holder, you have to have been in that status for 5 years and have 40 qualifying quarters of work history. That's roughly 10 years of work history to qualify now for SSI. So essentially, if you're a green card holder, you have to be a worker who has a work history, who's no longer able to work. Finally, if you're a cross-border Native American or connected to a member of the U.S. Armed Services, you may be eligible for SSI even if you entered the country after 8/22/1996. The next benefit we want to talk about eligibility for is food stamps, or now known as SNAP benefits. If you're a humanitarian entrant, you're eligible for food stamps, and there's no time limit as there is for humanitarian entrants and the SSI program. If you're some other qualified alien status that Barbara went through, the list of qualified alien statuses, if you're not a humanitarian entrant but some other form of qualified alien, such as a green card holder, you have to be in that status for at least 5 years before you can be eligible for food stamps. Finally, there's no 5-year wait for the following groups that are not included among the humanitarian entrants. That's the green card holders with the 40 work quarters of working. They're children who are under the age of 18, and people who are disabled in the sense that they've been found disabled by either the Social Security Administration or some agency that applies the same rules as the Social Security Administration. And then finally, the other group of immigrants that is eligible for food stamps is the Hmong Highland Laotians are also eligible for food stamps. Finally, we want to talk about the rules for the 2 other main federally funded benefits. That's family assistance, which is known nationally as TANF, which is the welfare grant that's federally funded, and federally funded Medicaid. The rules for these benefits are that if you were lawfully residing in the United States pre that magic date, August 22nd, 1996, then you're eligible. If you entered after August 22nd, 1996, you're only eligible for family assistance if you're a qualified alien. Now, some qualified aliens have to wait 5 years, just as they do for food stamps, before they can be eligible for these federally funded benefits. But I just want to remind you that there's no waiting period if you're a humanitarian immigrant or if you're a green card holder with that robust work history, that 10 years of work history that translates into 40 qualifying quarters. Finally, I should mention, as Barbara did earlier, that if you entered post-August 22nd, 1996, and even if you are eligible for these federal benefits, you may be subject to deeming and sponsor liability, although in New York State this is not an issue.
So now we're going to turn to New York State as an example of a state, and it is not the only state that has done this, that has kept a classification called PRUCOL, permanently residing under color of law, as the classification of immigrants who are eligible for the state-funded and state and locally funded benefits. Of course, for state and locally funded benefits, immigrants with federal qualified alien status are all eligible. But we're now going to be turning to the group that had been left out of the qualified alien category. And in New York, as I mentioned before, there is no 5-year waiting period for Medicaid or for the state's welfare system. And I have to say, I deal with a lot of questions. People call, and I'm still getting questions about can the welfare department say to someone, you're not eligible for anything until you've been here for 5 years. So that's very much still an issue, even in New York, which has been providing benefits for people without the 5-year bar since '96. Also in New York, there's no limit as to how long a poor person can continue to receive welfare. We do not have a 60-month or 5-year limit, so that households who come to the end of their 5 years of federal welfare eligibility will be switched into the state welfare program if at that point they are still needy. So let's go now to the question of these PRUCOL immigrants. Who are PRUCOL immigrants? Well, PRUCOL stands for a concept that means permanently residing under color of law. It actually was a federal benefits concept back before 1996, but it is no longer so, and it is now only operative in some states, by far not all states, and each state has its own definition of what it means to be PRUCOL. Like the qualified alien category, I want to emphasize that PRUCOL is not an immigration status. No one will get a card from immigration that says that they are a PRUCOL immigrant. It is defined by the particular benefit program. And because historically the concept came out of federal benefit programs, and there are differences with respect to how particular programs categorize or define PRUCOL. And in New York, in general, cash assistance is available to people who are known by immigration to be here and to whom immigration has given permission to stay. But for Medicaid, both people who have been given permission to stay, but also people who the Department of Health has determined immigration is allowing them to stay because they've made contact with immigration and immigration has made no move to remove them or deport them, and they are in essence processing their application for an immigration benefit. So again, because this is sometimes a very difficult concept to understand how one state can use different criteria for its benefit programs when it comes to immigrants who are considered PRUCOL but not qualified aliens. And really the big difference, and this is I mentioned before, is that the Office of Temporary and Disability Assistance, which is the state agency that administers the welfare program, does not acknowledge that people who are just in the process of applying for an immigration benefit, for example, somebody who is applying for adjustment of status to permanent residence, they do not accept that that falls into the PRUCOL category. Medicaid, the Department of Health, which administers the Medicaid program, does, characterizing that as an acquiescence by immigration while it is to the person's continued residence, while immigration is processing the application for an immigrant benefit. Now here are these are the categories of PRUCOL upon which both OTDA and the Department of Health agree. And these are all, and the reason that OTDA agrees with these is because these are people who actually hold a grant, an immigration benefit, have actually been expressly permitted by immigration to remain in the country. The first that I want to cover is called deferred action. And basically, deferred action it's not an immigration status so much as it is immigration saying to the individual, we know you're here, you are not in a lawful permanent resident status, but we have no intention of moving to deport you. And usually deferred action is given to someone who is in the process of applying for a benefit. So for example, if you are the battered spouse of a U.S. citizen and you have applied to self-petition, if that self-petition is granted, the person is given deferred action, which allows that individual time to then apply for a permanent resident card. An order of supervision is something that immigration, it's usually actually the immigration court, provides to someone who, although they actually have been ordered deported for various reasons, the deportation cannot be carried out. The most common example of this is a Cuban person who may have been put into deportation because of the commission of a crime, but because we have no treaty with Cuba for the repatriation of Cuban nationals, the Cuban cannot be sent back to Cuba. Instead, he is given what's called an order of supervision, which means he has to report to Immigration and Customs Enforcement regularly, but he can apply for employment authorization and he can work. And in New York State, that person is eligible for Medicaid and cash assistance. Grant of cancellation of removal, actually that automatically results in a green card, but in the period between the court order that says, and this is granted to someone who makes the case that they should not be deported or removed, usually because of the length of time they've been here and the fact that they have children. When they've been granted cancellation of removal before they get their green card, they are considered in a PRUCOL classification. I'm going to skip the next one because that's actually not very uncommon, this grant of parole for less than a year. The visas I have here, the K3, K4, and V visas are family visas. They allow individuals who are in the process of applying to adjust their status to be in the United States and to work in the United States. The K3, K4 are for spouses and children of U.S. citizens. The V visa is for spouses and children of lawful permanent residents. The U and S visa, the U visa is, of course, a visa for a victim of crime. The S visa is for someone who provides help to law enforcement. In both of those cases, both U and S visas, those visas can lead to lawful permanent residence, and that is why they're considered a PRUCOL classification and provides access to New York State Medicaid and cash assistance. The last category is actually not somebody who necessarily has an immigration document, but registry aliens are people who have been residing continuously in the U.S. since on or before January 1st, 1972. It's the only time where your length of residence in and of itself is a basis, actually, for adjustment to permanent resident. And there's a provision in the immigration law that allows people in those circumstances to file for a green card. Even without doing that, if you can show to the welfare agency that you have been living in the country since before January 1st, 1972, you should be considered eligible for cash assistance and Medicaid based on the fact that you meet the requirements for registry alien.
Finally, we just want to briefly mention, because we don't think the discussion would be complete without it, what benefits those residents who are undocumented are eligible for. And contrary to what a lot of people assume, if you're undocumented, at least in New York State, there are certain benefits that you're eligible for. What do we mean when we say undocumented? We're basically talking about two groups. Those who entered the United States without inspection by Customs and Immigration or Border Patrol, and those who came here with a visa, such as a tourist visa or a student visa or a work visa, and overstayed the term of the visa. That's who we're basically talking about when we say undocumented. So here's a list of what benefits persons who are undocumented are eligible for, and you'll see, you can take a look at it at your leisure, that it's a combination of emergency medical assistance, such as emergency Medicaid and Medicaid for pregnant women and teens, and nutritional supplementation. Since obviously undocumented persons are not eligible for food stamps, there is some basic nutritional assistance that's available both through the schools and as a food stamp like Subsidy, where it's for a pregnant mother or a young child. That's when someone who's undocumented is eligible. Finally, just to bring it all together, we want to give you a summary of these rules, and this summary basically applies to the rules as they exist in New York State. And the order in which these benefits are listed, you may have gathered already, is the order in which they are from most accessible to least accessible to immigrants. So Medicaid, as Barbara was discussing, is the most accessible benefits to immigrants in New York State because of the expansive PRUCOL definition used by the State Department of Health. The next most accessible benefit is cash assistance, and remember this is welfare grant, whether it's federally funded or state funded, and this is available to all immigrants with a qualified alien status, as well as immigrants who are considered PRUCOL by the Office of Temporary Disability Assistance. The next most accessible benefit, and this is really not very accessible, is food stamps. Only immigrants with a qualified alien status and non-disabled adults who are not humanitarian immigrants have to wait 5 years to be eligible for food stamps. Finally, there's SSI, and for those who entered the country after August 22nd, 1996, SSI is available if you're a humanitarian immigrant, but only for a limited time, for green card holders who have a pretty substantial work history, and for armed service-connected immigrants, but for no one else. So now we want to go to our next poll question. We're going to open the poll on this question. And the question is, Matt was granted asylum on March 16, 2008. On September 18, 2010, he adjusted to LPR status, legal permanent resident status. His status has not changed since September 18, 2010. He is not disabled, and he is 25 years old. The question for you is Matt eligible for food stamps? The possible answers you have are A, Matt is eligible for food stamps because he was an asylee. B, because Matt adjusted to legal permanent resident status, he is no longer eligible. C, Matt is not disabled or under age 18, so he is ineligible. And D, Matt has been here less than 5 years, so he is ineligible. So please consider those answers, and let's see how you do. Again, the question is Matt eligible for food stamps? Just take a guess if you don't know. This is not an easy question. We'll go through the answers. A is Matt is eligible for food stamps because he was an asylee. B, because Matt adjusted to LPR status, he is no longer eligible. C, Matt is not disabled or under 18, so he is ineligible. And D, Matt has been here less than 5 years, so he is ineligible. Okay, so the majority of you answered A or D. Those of you who answered A are correct. Matt is eligible for food stamps because before he adjusted to legal permanent resident status, he entered the country as an asylee. And so for the purposes of food stamp eligibility, and we didn't really go over this in detail, so it's pretty amazing you got this answer correct, so many of you did. Basically, once an asylee, always an asylee for the purposes of food stamp eligibility. So those of you who selected A are correct. And D is also a good answer. I can understand why so many of you picked that answer, because as we mentioned, if you have LPR status, generally speaking, and you're not disabled and you're not a child, you have to wait 5 years before you're eligible. So that's a good answer. And then, of course, we designed this so that all the answers would have some credibility. So for those of you who picked B and C, you know, you're not totally far off. I mean, these are rules that we went into, but because Matt was an asylee first, that's why he's eligible for food stamps now. So good job to everybody.
The last section we want to cover is the common concerns. I mean, even with all of these rules, there are additional concerns that people in the immigrant community have and their advocates with respect to confidentiality and reporting to immigration, a worry that if I go apply for benefits, somebody is going to call immigration and tell them I'm here. Public charge, if I get benefits, if I access these means-tested benefits, then I'm going to lose my immigration status, or I'll be deported, or I won't be able to become a citizen. And finally, the concern about one's sponsor. Immigrants who are sponsored worried that their sponsor will get angry if they need to turn to means-tested benefits. So these are all very much concerns and continue to be concerns in the immigrant community about this whole question of applying for public benefits. So, and one of the reasons the concern actually arises is that many programs, benefit programs, for example, food stamps or cash assistance, really require everybody in the household to be listed on the application. And very many households in New York State are so-called mixed households, households in which there are members, usually the kids, who are citizens, but there may be ineligible immigrant parents. The general rule that has been articulated by the federal government, actually by various agencies in the federal government, is that benefits agencies must be very careful in terms of their application procedures so that they don't deter applications made on behalf of eligible household members because maybe some member of the household is not eligible. So, for example, let's say an undocumented parent applies for food stamps on behalf of their children. The application itself makes it clear that an undocumented parent can do that. And the application has to be processed for the members of the household that are eligible. And the agency cannot push the parent to disclose just what immigration status they do or do not have. Probably the biggest concern for immigrants, especially those who are without status, applying for benefits on behalf of their family members, their children, for example, is that they'll go in and make an application for benefits, and the worker will just call up immigration and say, oh, I just want to let you know who's here. There's somebody here who can't prove that they're here legally. And so this worry understandably deters people from making applications on behalf of their eligible household members. And there is a basis for that concern because the 1996 welfare reform law did impose a requirement that agencies report not lawfully residing immigrants who are applying for benefits. But the rule has been very narrowly interpreted. And basically, the way that it's been interpreted is the only time that a welfare agency or any of the other agencies like a housing agency is to report an immigrant to immigration is if that immigrant is applying for benefits on their own behalf and when asked for documentation of their immigration status, it produces an order of deportation. So this is not likely ever to happen. So really the rule is very narrowly interpreted. However, it does have this chilling effect. In New York, the local social services district, or HRA, has no authority at all to contact immigration directly. They've been instructed by the state that if someone should apply for benefits and should produce an order of deportation, that person's name and address is to be transmitted to the state. And under no circumstances should the local workers in local districts make that contact themselves. The concern about public charge is also something that is very much in a concern in the immigrant community because everybody kind of knows that being a public charge is not a good thing because somehow it could affect your immigration status. The reality is that there are only, number one, there are only certain kinds of benefits that even create the risk of public charge. And those are just cash assistance, welfare, and long-term care in an institution. The other fact is that the only time immigration gets a chance to look at whether you've used those kinds of benefits is when you're applying to adjust status to permanent resident. So if you are already a permanent resident, there is no harm or danger in accessing public benefits. And there is never a reason to be concerned about using benefits if you are a lawful permanent resident who wants to apply for citizenship. There's also a lot of people who are not subject to public charge at all. For example, all of your humanitarian immigrants are not subject to public charge. So we've actually, and the USDA has tried very hard to make it clear to people that getting food stamps is not a problem. For people who are eligible for food stamps, there is no harm at all in applying for food stamps and getting them as far as immigration status is concerned. The last issue that people are concerned about in the immigrant community is this whole question of sponsor liability. If I apply for benefits, what will happen to my sponsor? Will my sponsor go to jail? Will my sponsor be forced to repay the benefits? The law itself does raise these terrible risks. The reality is that we've been working in this area for many, many years, and I have, certainly in New York, yet to see a case where the welfare department is trying to get a sponsor to repay benefits. In New York State, there's an explicit prohibition against going to court to try to get food stamp benefits repaid. The Department of Health has made it clear that we do not have the regulations in place to apply these rules to Medicaid. So the only little corner of sponsor income liability that's left that might be a concern is if the local district decides that they want to recover welfare benefits from a sponsor. Again, I have to emphasize we know of absolutely no cases in New York where that has been done. What is more common is that the whole sponsor liability issue is often used by social services districts, especially in some of the smaller counties, rural counties in New York, as a way of deterring people from applying simply by making them nervous about this whole sponsor liability issue. Okay, so we're going to go to our last poll question, and the question is, Maria has lawful permanent resident status. She recently lost her job. Her sponsor is employed but is not helping her. She wants to know the risk of her being found a public charge if she gets welfare, food stamps, and Medicaid. Now, which of the following would be the right advice to give her? The answers from which you can choose are: she can't be a public charge because she used to work. Getting welfare does not make you a public charge. And if Maria's sponsor works, Maria is not a public charge. Or you have the choice of saying that none of the above are the right answer. Let's see what the answer that people have chosen. You're still thinking about it? Okay, we have some responses. Well, the majority of people, you got it right. None of the above answers were correct. The reason none of the above are true, actually, is because since Maria is a lawful permanent resident, she is no longer under this public charge concern. So, not for the reasons that we've set out there, but simply because she is a lawful permanent resident, and so there are no risks to her in terms of accessing benefits.
Okay, finally, we just want to talk a little bit about advocacy. As I'm sure you're aware, anytime a government agency fails to grant benefits to a person who is eligible because of his or her immigration status, there's an opportunity for that person or his or her advocate to do some advocacy. So we want to talk about briefly 3 forms of advocacy. One is litigation. And in New York City, advocates, with the help of Barbara's organization, the Empire Justice Center, sued the city and specifically the welfare agency, HRA, as well as the 2 state agencies that administer government benefits, back in 2005, and the name of that lawsuit is MKB versus Eggleston. And the reason that suit was filed is because HRA, the local social services agency, was denying many, many immigrants who were eligible for benefits, those benefits, saying that they weren't eligible because of their immigration status. So, for example, if someone came in with a legal permanent resident card or green card and said, I want to apply for benefits, and we already discussed they are eligible for state-funded cash assistance as well as Medicaid, HRA would say, you need to be here 5 years before you're eligible, confusing the federal rule for the state rule. Or a woman who had filed a VAWA self-petition came in and said, I want to apply for benefits, and they said, you're an illegal alien. So for that reason, we sued HRA, and it resulted in a settlement under which thousands of immigrants have received retroactive benefits, food stamps, cash assistance, and Medicaid that they would have received at the time had their applications been processed properly. So we consider this to be a successful example of litigation in this area. The settlement agreement is still in effect, and we'll talk in a second about how if you have a client who is being denied benefits for which they're eligible currently, you might take advantage of that settlement. Another form of advocacy are administrative hearings, also referred to as fair hearings. And as you may know, the United States Constitution requires that a person who's losing property, such as welfare benefits, be given something called due process. They be given a fair process for determining whether they, in fact, should be losing their benefits. And what the Constitution requires with respect to welfare benefits is that they be given a hearing before an impartial judge. In New York State, it's an administrative law judge who's employed by the state who can consider whether the applicant or recipient of benefits was properly treated by the local agency. And so that's one form of administrative advocacy, is representing people at fair hearings. Another form of administrative advocacy is at the agency level. So when we think as advocates that there's an immigrant or an immigration status that should be eligible for benefits, for example, because person in that immigration status we think should be considered PRUCOL, but has not been heretofore recognized as eligible by the state, specially trained and knowledgeable advocates such as Barbara are able to approach the state and advocate that the state should expand its way of thinking about who's eligible for what and include formerly unrecognized categories of immigrants in among those people who are eligible for benefits. So that's something that only very few of us are really trained or able to do. So what if you, the participants in this webinar, see an issue related to immigrant eligibility for benefits? Well, if you're in New York City and the person you're concerned about is in New York City and they fall into one of the following 3 categories, they're PRUCOL, whatever definition you use, they've had their legal permanent resident status for less than 5 years, or they're a bad or qualified alien or someone who's filed a VAWA self-petition, and they're being denied benefits for which they're eligible by the Human Resources Administration, I may be able to help you get relief through this MKB versus Eggleston settlement that I mentioned. So if you have someone that you think meets those criteria and they're being denied benefits for which they're eligible, you should give me a call. That's my direct office line, and you should just feel free to give me a call. If you see similar issues outside of New York City, Barbara has included her number in the materials here, and so you could give her a call if you're outside of New York City. What if you have a client who has a general problem in accessing public benefits? It doesn't really have to do with immigration status. Well, if you're in New York City, I've listed the numbers for my organization, the Legal Aid Society. We have offices in every borough, and so you can refer someone to our offices by having them call the appropriate borough for assistance, and the receptionist will tell them what they can do to get help. If someone needs, another option for people who need help is to visit a small nonprofit organization called Project Fair, which has a table that's set up right in the state office building where fair hearings are held at 14 Boren Place in Brooklyn. And people can show up there without an appointment any business day between noon and 3 p.m. So that's a great option. If you have people who are having a problem outside of New York City, there's legal services offices that cover every county of New York State as well as others, and so you can easily find the appropriate office for the person who's having a question. So that's the sum total of what we wanted to say in this limited amount of time to you on immigrant eligibility for benefits rules, and I think now we're going to open it up to questions.
Okay, while we were giving our webinar here, several questions did come in, and we're going to try our best to answer them as quickly as we can. The first question was, when an applicant brings their documents to the Social Services Agency, does the agency verify their immigration status? And yes, the agency is actually required to verify the status. Now, usually that's done by the agency worker looking at the document and then looking to see where in the list of statuses, qualified alien or PRUCOL, the individual falls. There is a system called the SAVE system, and this is also used by local districts, which takes a copy of the document and sends it to immigration, a special system that will verify that indeed that individual is a lawful permanent resident, or may say that document is a forgery, or the person's that person's status has expired. So yes, the local agencies do verify, on occasion verify the status, and there is a section in all of the applications for benefits which acknowledges that the person knows the information they give with respect to immigration status can be checked with immigration. Okay.
Okay, so the first question I'm going to answer is as follows. If an undocumented immigrant gives birth to a United States citizen child, in other words, gives birth while the person is residing here, is the child eligible for benefits? Yes. If a child is born here, even if they're born to someone who doesn't have immigration status, they are eligible for all the benefits any U.S. citizen would be eligible for. It is only the parent, in this case the mother, who is not eligible for benefits, other than those certain emergency Medicaid and Medicaid for pregnant women and some supplemental nutritional assistance that we discussed that undocumented immigrants are eligible for. So that's a pretty easy question. There's one more question that we were going to try to answer in the limited time that we have left, and that is, one of you wanted to know what benefits a person who has a VAWA self-petition is eligible for. So a person who has a VAWA self-petition has filed what's called an I-360 petition, and that person is a qualified alien, And so if you look back at your PowerPoint and see where Barbara and I discussed what qualifying aliens are eligible for, you can answer this question for yourself. But I'll tell you that someone who's a VAWA self-petitioner is eligible for cash assistance and is also eligible for Medicaid. Now, if you're a child of a VAWA self-petitioner who was included as a derivative on the petition, you're also eligible for food stamps, because remember that for a regular qualified alien, you have to wait 5 years for food stamp eligibility, but if you're a child under the age of 18, you can get food stamps immediately. So mom and child are eligible for welfare and Medicaid, and just the child is eligible for food stamps until the mom's been in qualified alien status for 5 years.
Okay. Thank you very much, Susan and Barbara, for that really thorough presentation. And I apologize we didn't have a lot of time for question and answers, but there was really so much information that Susan and Barbara wanted to give. And they graciously provided their information. So if you have questions, you can follow up with them or the other numbers that Susan provided. There's just a few people we want to acknowledge that are listed here from CUNY. If you have further questions about this webinar or webinars in general, you're more than welcome to email me. My email is listed, patriciawonder@johnsonwonder.com, and I'll be happy to answer any questions that you have or refer you to someone who can help you. I want to thank you for joining us today. I want to thank Barbara and Susan for that really great presentation and the thoroughness and the care that they gave and the work that they do for the immigrant community. I want to tell everyone and remind everyone that we will not be having a webinar in April. CUNY is devoting so much time to the call-in that there will not be a webinar in April. You are more than welcome to register at the CUNY Citizenship Now website so that you can take advantage of that training that will be streamed on the web on March 30th. And you're also more than welcome to register to participate or call in for the call-in that is the week of April 25th to the 29th. We will reconvene on May 19th for our next webinar, which will be on family-based immigration. So please look for that. And thank you so much again for everyone. I hope you enjoyed the presentation. Thank you to Barbara and Susan, and we're done. Thank you.